And these are some of my thoughts how we could really turn things around, if we wish, if everybody wants to do it. So building the institution is building trust and public confidence of the people in the institution. Unless people trust us, unless people have confidence in the judiciary, that's the basic test, you see. People need to have confidence. That's how we function. That's what our strength is, the public confidence and public trust. So we need to be independent. We need to look at our integrity issues. We look at our transparency, our efficiency, our knowledge, and our research base. You see, these are some of the areas that we... So how do we go forward? Now, first thing that comes to my mind is that we need to be very clear about our jurisdiction. We cannot start interfering, and I've already said this earlier, we need to stay away from judicial overreach. And you all know this has happened in the past. The court has committed judicial overreach many times. We need to understand our jurisdiction would be the first thing and stop interfering in the domain of the legislature and the executive. We just attend to the list that we have. We have 2 million cases in Pakistan. We better attend to those cases rather than attending to areas which are not ours, you see. So we need to stay within that domain. The other thing is that we need to understand that there is judicial activism, which is legal and which is acceptable, and then there is judicial restraint. And we need to understand when to use both. Judicial review has these two options. You could have judicial activism, you could have judicial restraint. But you need to be intelligent enough to understand when to go for judicial restraint and when to go for judicial activism. Both are legal concepts, but it has to be understood. The two approaches need to be applied cautiously. So some find change and innovation more important. Depends on the judges. Some judges are more conservative and might go for judicial restraint. The other are slightly more liberal, progressive, and might go for judicial activism. But this has to be this has to be understood and applied cautiously. In the army chief case, which people might have objections to it and might have some questions relating to it, judicial restraint was exercised. In a sacked employee's case recently, judicial restraint was employed. So depending on what the nature of the case is, you could understand that and apply that accordingly. But judicial review cannot be used to promote politics or to attend to political aims or play politics. That's not the scope of judicial review. It has sadly happened in the past. I don't want to get into the areas, but judicial review can only be to promote the constitutional values. It cannot be to play politics in any manner. Coming to suo moto, it has been abused over the years, Article 184(3), and we need to have a serious check on this, absolutely serious. The judge is not a king, or Supreme Court is not a kingdom, you see. We need to be very careful. We are applying the Constitution. I'm bound by the Constitution and the law and have to act in accordance with law like any other institution. Only matters of enforcement of fundamental rights of public importance might invoke suo moto at times, only to promote fundamental rights. Suo moto cannot be employed to curb fundamental rights in any manner. So, to my mind, if at all suo moto is to be exercised, it could be exercised to pull up the minorities or to help the backward and depressed classes that are mentioned in the Constitution. It is just a people-centric provision, and it could only be done to attend to a class which is really in trouble, and sparingly done, and that's about it. We can't sort of interfere in other things, and I don't want to go into the areas that we've interfered in, but that's not the purpose of suo moto to my mind. I think we need to curtail that seriously. And unless there is any other remedy available, let those remedies be taken, and you just cut to this only if there is a serious issue of fundamental rights of a particular class, and that too downtrodden and weak and poor and vulnerable, that you probably get. But suo moto cannot be used to jump into a political thicket, you see, to understand, resolve political issues, not our problem. We are not going to use suo moto for policy areas. That is not our area. And suo moto cannot be exercised by a particular bench or by one individual or by the Chief Justice. It must go to a larger bench on which the person who's proposing to take a suo moto action is not a member. I think it should have a bench of 7 members at least who would just decide whether at all we're going to entertain this matter of suo moto or not, which has been proposed by a judge of the court. So that is required, and we need to provide an appeal in case the court goes into a suo motu action. There must be an appellate forum to the suo motu. On the judicial governance, largely, institutions run through consensus, participatory approach, and ownership run through. So the Supreme Court has to, or the judiciary has to be run through some sort of a collective board. Our entire set of institutions, be it Supreme Court or the High Court, is very Chief Justice centric. Everything, Chief Justice calls the shots. But you must understand the Chief Justice is the first person to leave the system. He's there for a couple of months. We don't have a tenure system, and I'm proposing that we must. We must have a minimum tenure of a Chief Justice for 3 years or 2 years or so. If the Chief Justice is there for a couple of months and the whole system sucks up to him, there's no way that we can sort of evolve or come up with judicial reforms or policies or anything to that effect, because there's no long term there. So there has to be, we need to rethink that the courts need to function through a board, you see. So in case the Chief Justice is gone, the policies stay, and there is continuity in the institutions. Lack of continuity has been a biggest problem that Pakistan is facing. A Chief Justice comes for 3 months, comes up with whatever he decides to do. It's all undone by the next chap. So 1 step forward, 10 steps backwards, and that's where we are right now. We're just doing this in and out for several years. So I think we need to have a constitutional amendment to talk about a tenure for a Chief Justice. And a Chief Justice of the Supreme Court cannot be a Chief Justice unless he's been a Chief Justice of the High Court. It is critical that he's had administrative experience and an understanding of administration before he takes over the apex court and looks at the national judicial system. He needs to have that experience. So not everybody should become a Chief Justice. This is something on the internal governance that we need to consider. The elevation to the bench is critical also. We need to make sure, and it's very important, that there is integrity, there is courage, and there's competence, there's diversity. Yes, I fully agree with diversity. I'm very happy that we have a female judge now at the Supreme Court. But that's not as a policy. That's a one-off thing, you see. We need to have a policy. Why can't this happen at the High Court? Why can't this happen at the district courts, you see? Just one-off person elevated to the Supreme Court, very good. I welcome that. But this should have been a part of a big policy, which is not there. There is no policy. So what do we do next? I mean, will there be a next judge coming to the Supreme Court? We don't know, because it's just a one-off thing. So yes, diversity, minorities also need to come to the Supreme Court, and we need to have that. But not only the Supreme Court, we need to do that for the High Court. We have 500 female judges in the district courts. We need to talk about that too, you see. Where is, diversity and gender preference there? I mean, we're not really thinking about that. So we need to think about this entire elevation business. I think it should be advertised. I think we need to reach out to the bars of the country to send their names who should be elevated to the High Court. And there should be a test, and there should be a proper, interview, and we need to consider people from all across the province or the country when we are considering somebody for the courts. And it should not be based on just selection on our own or selection of a few people. That's important. And I think Supreme Court material would be somebody who's creative and inventive. And if he's not inventive and he's not liberal and he's not creative, I think the person is not supposed to come to the Supreme Court, because Supreme Court doesn't require operational judges who would just look at criminal law, look at civil law. That's not what we need. We need somebody who looks at policy, so he's higher than the civil and criminal law, so that he creates jurisprudence for you. He has to be slightly different. So that's what we need to start considering. So, and judicial reforms are important. Now, it's very sad, you see. I don't know if there have been judicial reforms in the real sense in our country. It's been 75 years, and I think we need to sit down and do some serious judicial reforms. And for example, case management itself is just a basic reform system that we need to do. Bring in technology, bring in artificial intelligence. How are we going to deal with 2 million cases? No clue. Nobody has any idea what to do with it. Case management is an accepted technology, accepted technique all over the world. We need to bring that in. We need to start moving cases. We need to start categorizing cases of children, women, infirm people, old people. They can't just be there. I mean, it's a cliche. In Pakistan, generations go through cases. I mean, one big reform, if that can take place in Pakistan, is that the matter or the list should be decided in a maximum of 1 year, from trial court till the Supreme Court, and you're done. And that will revolutionize the country. If you were to decide a case from the trial court till the Supreme Court in 1 year, you're out of the justice system, you have changed the way the country works, totally changed the way the country works. But this period, from trial court to the Supreme Court, takes 25 years. The rent seekers, you do whatever you want to do with the system. I can get an injunction and sit on it for the rest of my life, destroy the economy, destroy everything, cannot function. So one reform, if you were to ask me, is just make sure that the shelf life of a case in Pakistan is not more than 1 year. You're out of my justice system, do whatever you want to do, but you're out of the justice system in 1 year. That needs to be worked on. And I think we can, with the artificial intelligence, with technology, we can come up with that. We've also come up with video linking, and that's been a major, Justice Khosa started it, but it's a great lesson, and COVID has really reaffirmed that. I think we need to get into this video linking business, and a lot of adjournments, which is a curse in Pakistan. 80% of our work gets affected by adjournments, could be sorted through video linking, which is now very established technology. We're also promoting, there was a judgment recently where, I was the dissenting judges, but the majority judges didn't agree. We wanted live streaming of our proceedings. Every court is doing live streaming. What could be more transparent? Especially 184.3, which are public interest cases, which says it is of public importance. How would public not know what's happening in a 184.3 case? It should be live streamed. And that is something that we need to be heading towards. That adds transparency. Let people understand. Let courts have no walls. Let people see what's happening inside the courts. The more you open it, the more efficient, more transparent you make it, you see. And that's how we should be looking at the Supreme Court. We need to also time our hearing. You see, if you come to Pakistan, you see, Mr. Raja is sitting here, they could go on endlessly arguing their case, you see. We need to have timing. We need to have, the Supreme Court in US, we could, and come up with skeleton arguments, you see, so that we move on to the next case. We just can't go on for hours and hours on a particular case and keep hearing the lawyer repeatedly, because they have their own issues of articulation. We need to also move on to mediation. You see, we cannot decide all these cases. We cannot decide 2 million cases. We need to move on to ADR. We started off with mediation. I think the country needs to be infested with mediating centers or mediation centers where people are resolving the disputes. Family issues, rent issues, corporate issues, tax issues could be resolved through mediation, and that's the future. We need to encourage and move towards mediation, and that is, we're lagging behind. We don't have a proper arbitration mechanism. We don't have commercial arbitration centers in Pakistan. We need to get in that direction and move in that direction also. We've also come up with, and I will share that with you, but we need to do it at a national level, we've come up with the gender-based violence court, you see. Now that's very important.